If I create a nuisance by putting paint on that wall over there that I know is toxic, at some point in time, I have to remove that paint from the wall. If I know it's toxic when I put it up, that's what the issue was in the case. So in terms of public nuisance, it was all about removing the paint from either the exterior or interior walls. This was an example of a case where the defense just would never say yes to anything.
It was 13 years of pretrial litigation, including 2 appeals, one of which went all the way to the Supreme Court. And one of them was the 6th appellate that really laid out the law of the case, which made it really great when we got to trial, that there was some law for the judge to follow in our case.
After 14 years, their position was on day 1 to 14 years later, or 13 years later, was that everybody knows, everybody out there on the street knows, that the level of toxicity is going down of lead paint. And the reason it's going down, which it is, the reason it's going down is that older homes are being destroyed, demolished to build new homes. They're not using lead paint since 1978 when the ban went in.
The defendants had been claiming all along and showing graphs of this declining levels of children who have lead poisoning. They've been beating that drum for years. And what was impressive, the most impressive about what the court ultimately found in this case is that it can't be a case that's just dwindled down to a percentage or statistic, because even when we looked at the current state of affairs where their charts were showing a decline in the number of children affected, we're still dealing with 10,000 children every year, just in the places where we were representing.
There has never been anything from the defendants except we're going to beat you, you have a terrible case, lead paint is not a problem, and if it is, we're not responsible. And we've heard that from day one. We're continuing to hear it even though the judge found 3 of the defendants liable, and we figure that we'll continue to hear it. And we all know that lead paint is a serious problem, and we believe, and the judge found, that 3 of the defendants knowingly promoted it and caused the serious injury that lead paint causes.
The act of gathering all this evidence was a very large undertaking, and it really involved dozens and dozens of people up and down the state of California going to historical societies, going to museums, and even all the way outside the state to Montana and to New York and to Boston, and libraries up and down the coast. And these teams of people went through magazines, periodicals, yellow pages, from the turn of the century in the 1900s all the way up until 1978.
Well, the documents were pretty clear. As a matter of fact, one expert I cross-examined had to admit that in the 30s, there were minutes from a meeting of the paint associations that would meet, Paint Manufacturers Association, where they actually said, don't discuss anything outside of court, outside of this meeting. Keep it all quiet. I mean, it was patently clear what they were discussing in the 30s. They were discussing the toxicity. So it was all about knowledge. So the documents we used showed that they had knowledge of the toxicity.
The paint manufacturer said that lead was no longer a problem, that it was not dangerous at low levels to children. So it was a big battle for us to prove that below a certain level it was dangerous. In fact, there is no safe level of lead for children.
As you know, they had somewhere around 100 to probably 150 different lawyers that worked on this case. And that's at any given time. In the courtroom during trial, they had sometimes 70 to 80 lawyers in trial.
We felt good about the way the case went in. The evidence, we had great experts, the medical experts were wonderful. And I think that as it went along, it was very much something that was concise and we felt well put together.
So the court found that to remove, for the 10 entities that we represented, the court found approximately $1,150 million for the removal of, and that's the inspection, the removal, and education. There's an education element that goes along with that.
It was very gratifying, the judge's decision. It was particularly satisfying for me, not only the now 14 years that we've been in the case, but I was a scientist before I was a lawyer, and I have a master's in public health and environmental and toxicology, and I studied lead. And so for me, this has really come full circle to combine my science and my law.
Well, I think that what I'm most proud of is obviously the result, because the $1.15 billion abatement fund can just do a tremendous amount of good for the kids in California, but also was a great group of people that worked together from all across the country, all through the state. Everybody contributed different things, but we all worked together because we all had the same goal. It wasn't easy every day, but it just was a great group, great cause, and I'm really proud of that.
Cody was a young man who had just gotten his high school graduation behind him and didn't have plans yet about whether he was going to be going to college or not.
He had grown up in the ranches of Bakersfield and wanted to become a rancher himself. He loved being around horses, he loved being out in the fields, he loved being outdoors. And he really thought of himself as a young cowboy.
He told his father he wasn't feeling well and got into the passenger side of the truck, but when his father came over to him, I think with a bottle of water, Cody sort of slumped forward.
When Cody first arrived at the emergency room, he was suffering from weakness in all four limbs, was unable to walk, unable to move, and was unable to talk. The nurse who first saw Cody in the emergency room and triaged him noted a primary complaint of possible stroke.
So one thing that they did immediately was a CT scan without contrast, although it took them longer than it should have taken to get it back because they did not call a stroke alert, as they should have. But the CT without contrast showed a small stroke. It's called a lacunar infarct, a small stroke of indeterminate age in the thalamus, which is a deep brain structure in the back of the brain.
When Cody's test results came back abnormal, the physicians responsible for caring for him didn't act as the standard of care required.
If the clot is sort of staying put or even dissolving a little bit as the body's trying to cope with it, the patient can get better. And so his course waxed and waned all night, which is classic for this type of stroke, and it was crucial to proving that there was still a window of opportunity for treatment to make a huge difference. And that was where the big battle was.
Approximately 8 hours after Dr. Hansa chose to admit Cody rather than order a emergent neurologic consultation, the blood clot in Cody's brain restricted the blood flow into his brain so severely that Cody began deteriorating significantly. His body seized up and he started foaming at the mouth. By the time Cody's physicians discovered what was truly causing his symptoms, Cody's condition was permanent and catastrophic. He was left with spastic quadriparesis. He's bound to a wheelchair, needs assistance and supervision 24 hours a day, and will never be able to live the life of a cowboy that he dreamed he would be.
Several months before trial, all the defendants, except for Dr. Hansa, settled the claims against them. And then 2 weeks before trial, right after I finished the deposition of one of Dr. Hansa's causation experts, the attorney handed me a 998 offer for a waiver of costs and malicious prosecution. The defense position on causation was that by the time Dr. Hansa became involved, there was nothing he could have done to change the outcome. The verdict was unanimous that Dr. Hansa violated the standard of care and caused harm to Cody. The verdict was $12.3 million in present cash value. They also did a future value award.
The thing about this case that I'm most proud of is that 50 or 60 years from now, when the judge and lawyers have all passed away, Cody Myrick is still going to need someone to care for him, to watch him, to get him in and out of bed every day. And this verdict is going to assure that when that time comes, he is taken care of and he has the money he needs to live as decent and humane a life as possible.
Ken was a BMW salesman at the time that this happened. He'd worked his way up through the ranks at Ford and Volvo and Hyundai, and he'd finally gotten his dream job selling BMWs at Concord BMW and was actually working on the morning when the defendants came in for a test drive. The defendants in this case were a father and son. The father was actually an attorney who was working primarily in Beijing, and his son was a first or second year student at Duke Law School. So the test drive started with the elder Mr. Lee driving the car, and the first half went uneventfully. They then switched places, and it was important for us to show that the younger Mr. Lee was engaged in bad driving behavior really throughout the test drive, because the crash happened obviously at the end. And right after that, he tried to blame my client for telling him to hit the M button on the car as the cause of the crash. Mr. Gonzalez really just, at the time, looked like he got shaken up. Okay. This case presented a big challenge because my client had been treating for more than 4 years before he finally had his single-level disc replacement surgery. The most important job we had was to try and show the jury that these records painted a consistent and really unchanging series of complaints regarding his cervical spine that started really at the time of the crash and never got better. We know most people are chronologic learners. They like a story with a beginning, a middle, and an end, and timelines are superb at helping people understand the chronology and laying out for the jurors, exactly when things began and how they progressed over long periods of time. And we constantly go back to the timelines to give the jurors visual references to keep the narrative in our story concise and consistent. Kim Rodriguez was a 33-year-old single mother who had worked for a number of years as a medical billing assistant at dental offices. She also had 4 children, one of whom was developmentally disabled, with 3 different gentlemen, none of whom she ever married. And that presented some unique challenges at trial. This case involved a 3-car crash on the 880 freeway, but unfortunately Ms. Rodriguez was the first car in line, and there really was very little damage to the rear of her car. The fascinating part of trying the Rodriguez case right after the Gonzalez case was that they both had the same injury and the same treatment. They both involved single-level disc replacement surgeries at the C5-6 level, and it was very interesting to get a chance to see how 2 different juries in very similar jurisdictions, Coco and Hayward I thought were very similar, how they would approach their task and the things that they would focus on in these 2 very similar cases. One of the most interesting things about looking at these 2 cases tried really a week apart and in 2 similar jurisdictions was the difference in the jurors' non-economic award, $1 million in the first case, $500,000 in the second case. And really the main difference, the main determinant, I believe, was the fact that the defense counsel in the second case were much nicer and more personable and much kinder to my client, and really tried to show the jury that they were trying to take responsibility and be reasonable. The defense in these cases always wants to look at the MRIs, as evidence that there was no acute injury, or to get an orthopedist who will testify that, he sees these types of changes on MRI and all of his patients above a certain age. And, what they all ignore is the 800-pound gorilla in the room, which is that our clients were doing just fine before they were involved in the crash that gave rise to this lawsuit. Thank you very much. Their lives were going along. They were living and loving and working and doing the things they wanted to do. The crash happens, and then there's a fundamental shift or change in how they have to approach their lives.
The Martinez family is an amazing family. Consuelo is a woman that grew up in Fresno, eventually went to Fresno State, got a degree in business, and worked for one of the largest employers in Fresno in the HR department. Quite the self-made woman. Francisco immigrated to the United States at a young age, worked hard as a laborer, worked hard to become proficient in being a tile setter, and was working his way there at the time of his death.
Initially, it was claimed that Francisco was an employee of the general contractor. Our primary defendants were then the homeowner, Herndon Partners, and Amador Electric, the electrician on the job site.
Where this incident occurred was in Malibu, California, on a very well-known road called Broad Beach Road, where all the homes face Malibu Beach. On the day that Francisco Martinez died, it was the last day of work. They were cleaning up the house and getting it ready for a broker's tour because the real estate brokers, were coming in to look at the house in order to sell it. And Palawati came to the house and found that the doorbell didn't work and told Mr. Bravo, get the doorbell working. Mr. Bravo then instructed Francisco Martinez to go underneath the house to find the doorbell line that was already down. It had been run down the wall into below the home. When Mr. Martinez was pulling on the fish wire and it pierced the line voltage, it electrocuted him and killed him. Of the 20 companies that Mr. Ohadi, 20 plus companies that Mr. Ohadi had created, there were 3 that were relevant in this case. A company called Sierra Pacific Construction Development, Malibu Pacific Construction Development, and Herndon Partners. Herndon Partners was the owner of the property on Broad Beach, which was the property that Palawati had bought and intended to renovate. Sierra Pacific and Malibu Pacific were each companies that held general contractors' licenses through Palawati.
Herndon Partners' contention during discovery was that it was solely a shell company set up to hold assets, and that Herndon Partners had no involvement in the actual work happening on the job site. The first indication that we were dealing with a shell game was when I went down to Fresno and took the deposition of the foreman on the project. This was a man who'd worked for Palawati for over 20 years, and during his deposition said he worked for Herndon Partners. After his deposition, the change sheet had him working for Malibu Pacific. As we know in California, if you're at work and you're injured, the exclusive remedy against your employer is workers' compensation. Of course, if your employer is uninsured for workers' compensation at the time of your accident, you then have a right to a third-party case against your employer.
We believe the path to victory was to show that Herndon Partners was in fact the employer. So if Herndon Partners is the employer of Francisco Martinez, then because they don't have a general contractor's license and they don't have workers' compensation insurance, then it's presumed that if Francisco Martinez is getting injured while he's working, that they're responsible for it.
We served a 998 early on in the case to open up Herndon Partners insurance policy. And again, because of their confidence that there was no way we could establish liability against them, they let the 998 lapse. The verdict in this case was over $13 million.
For Consuelo Martinez, this was never about the money. This was about making sure that Palawati got held responsible for what he had done. And his effort to cut corners, save money, he'd cost somebody their life. That wasn't necessary, didn't have to happen, it could have been avoided. And it was just a matter of dollars.
This case started as a personal injury case of Secundino Medina, who was a 79-year-old retired General Motors factory worker. He had worked first on the line and then later as a security guard at the Van Nuys General Motors assembly plant, where they put together the cars for a very long time. And at that facility, as part of the work that they did there, they did a lot of clutch repair work, and he was a security guard on the night shift, so he would stand by other people, mechanics, who were doing that work, and in that way, he was exposed to asbestos day in and day out. He was very ill. We immediately filed a case, and the first order of business was to take his video deposition so that whatever was the good information that he had, it could be preserved for later proceedings. So we did that, and unfortunately, like a lot of people, he was deposed literally at the end of his life for 4 straight days. The defendant's position on the case was that they had absolutely no liability whatsoever. The settlement offer that they made pre-trial was very nominal. I think they felt quite confident that this would be a defense verdict, and then they would use it to be able to show other plaintiffs who were trying to pursue asbestos cancer cases against them that you cannot win this case. As it all got laid out at court, started at the beginning of the last century in the 1920s. One of their main products was asbestos-containing automotive clutches. They knew by 1930 that the asbestos would hurt people and likely end their lives, and they sold it anyway. One of the difficult challenges of this case, there were several. Number one, what was the value of the case? Because Mr. Medina's wife had predeceased him, and his only sort of economic piece was a small pension and Social Security. There would be no, for instance, spouse left behind. What was the value of the case when the plaintiffs were his adult daughters who were around 50 years old themselves, and they had their own lives and their own jobs? The other challenges on the liability front were he was not a person who worked with the product himself. That was never his job. He was a security guard who was merely patrolling in the area where the products were used. The verdict in this case was $6.5 million in compensatory damages, $2 million in non-economic damages for each of the 3 daughters, and then there was some economic damages. Then there was $32.5 million in punitive damages. But ultimately, in my opinion, the jury awarded the amount of punitive damages that they did because it was clear that they knew that what they were selling was going to hurt people, and they sold it anyway. And when it came out in this case that in fact you had hurt someone, you had killed someone's father, grandfather, great-grandfather, beloved person in the community, they didn't step up and take responsibility. They tried to conceal it, they tried to hide it, they tried to deny the undeniable, and those are the kind of things that juries, good juries, really react badly to, as they did here. And then I think finally, the defense attorney helped quite a bit when we argued punitives, because he suggested to the jury, after everything they had looked at and heard, that this company, this major, humongous concern, would understand they did something wrong if they simply awarded $1 in punitive damages. I'm proud to be a plaintiff's attorney, and it is really the greatest gift of my life because I grew up on the south side of Chicago in a community that desperately needed lawyers, that desperately needed help, and we had none. And it was my dream to become a lawyer and help people, and I am working as hard as I can every day, but I am absolutely living the dream that I wanted to have since the time I was 6 years old.